State of Ohio versus Michael Murphy in cases 26 CR 860 and 26 CR 882. The defendant is present with counsel Tim Deeb. In both cases, informations were filed. In case 26 CR 860, a 3-count information was filed charging the defendant with failure to comply with an order or signal of a police officer, a felony of the 4th degree in violation of Revised Code 2921.331B. Count 2 is aggravated possession of drugs, and count 3 is possession of a fentanyl-related compound. Both counts 2 and 3 are felonies of the 5th degree in violation of Revised Code 2925.11a with forfeiture specifications. In case 26 CR 882, count 1, an amended information was filed amending count 1 to aggravated possession of drugs, a felony of the 5th degree with a forfeiture specification. And count 2 is possession of a fentanyl-related compound, a felony of the 5th degree with the forfeiture specification. It does say the amount in count 2. It says the amount does not equal or exceed 1 gram, to it 1.89 grams. I would ask to amend this language to just delete the 1.89 grams, and defense has stated they have no objection to this.
No.
Is that right?
Correct.
Right.
And it is the state's understanding today that the defendant would like to waive his right to have the Lake County Grand Jury indict both of these cases and will be pleading guilty by way of information, and there is no agreement as to sentencing.
Deeb?
That is a correct statement, Your Honor. My client wishes to change his plea and waive his right to have his cases presented to the grand jury at this time and proceed to the change of plea. We have been provided discovery in both cases by the state several weeks ago. So we've had an opportunity to go over all the evidence. We believe this is a fair and just result.
All right. Mr. Murphy, how old are you?
I'm 42.
How far did you go through school?
I graduated high school.
Are you a U.S. citizen?
I am.
Are you able to read, write, and understand the English language?
I do.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
No, sir.
You ever been diagnosed with or treated for any mental illness?
No, sir.
Did you get a copy of the information in case 860?
I did.
Any questions about it?
No, sir.
Did you get a copy of the information filed in 882?
I did.
Any questions about that?
No, sir.
With regard to both cases, you have the right to have your case presented to the grand jury for them to decide whether or not to indict you. Did you discuss that right with your attorney?
I did.
Are you going to waive that right?
Correct.
Your Honor, at this time, would you like me to sign the waivers of indictment? We've been presented with both waivers of indictment. We had an opportunity to go over those prior to coming into court, and my client intends to sign those at this time. Your Honor, my client understands that he is waiving his right to have his case presented to the grand jury. He has signed those waivers, and so have I.
Your Honor, I've witnessed Mr. Deeb and the defendant sign the waiver of indictment in both cases, and I've signed it myself in open court.
All right, I'll accept the waiver of indictment in both cases. Now, before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you, and I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, let me know. If you want to talk to Mr. Deeb some more, let me know that, and I'll give you more time. Do you understand that?
Yes, sir.
With regard to both of these cases, you have the constitutional right to have a trial either to me or to a jury of 12 Lake County citizens. You understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes, sir.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
I am.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
I do.
Are you waiving that right?
Yes, sir.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them testify. Do you understand that right?
Yes, sir.
Are you waiving that right?
I am.
You have the right to testify at trial if you want to. Do you understand that right?
I do.
Are you waiving that right?
Yes, sir.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes,
Are you waiving that right?
I am.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
I do.
Are you waiving that right?
Yes.
If you file an appeal, you have the constitutional right to have a lawyer represent you in the appeal. Do you understand that right?
I do.
Are you waiving that right?
Yes.
If you could not afford to hire a lawyer, one will be provided at no cost to you. Do you understand that?
Yes.
If you file an appeal, you're entitled to have a transcript of all the hearings in this case. Do you understand that right?
Yes.
Are you waiving that right?
I am.
If you could not afford a copy of the transcripts, they'd be given to you at no cost. Do you understand that?
I do.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes.
Do you have any questions about any of these rights?
I do not.
Do you still want to plead guilty to these charges?
Yes, sir.
You understand by pleading guilty, you're fully admitting your guilt to the charges.
Yes, sir.
You understand by pleading guilty to these felonies, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control.
Yes, sir.
All right, in case 860, count 1, failure to comply with the order or signal of a police officer is a felony of the 4th degree. It carries an 18-month maximum prison sentence and a $5,000 maximum fine. Do you understand that?
Yes.
Count 2, aggravated possession of drugs, is a felony 5 with a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
I do.
Count 3, possession of a fentanyl-related compound is also a felony 5 with a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
I do.
Now, I could give you a consecutive sentence in this case. That means one sentence after another for the separate offenses. If I did that, you face a maximum prison term in that case of 42 months and a maximum fine of $10,000. Do you understand that?
I do.
In 882, count 1, aggravated possession of drugs is a felony 5 with a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
I do.
Count 2, possession of a fentanyl-related compound is a felony 5, 12-month maximum prison sentence, $2,500 maximum fine. Do you understand that?
Yes, sir.
If I gave you a consecutive sentence in that case, you face 24 months in prison as a maximum and $5,000 as a maximum fine. Do you understand that?
Yes, sir.
If I ran both of these cases consecutive and maxed you out on each case individually, facing a maximum prison term of 66 months and a maximum fine of $15,000. Do you understand that?
Yes, sir.
If you plead guilty to the forfeiture specification in these cases, on each of these counts, you're voluntarily giving up whatever items are listed. Do you understand that?
Yes, sir.
Are you presently on post-release control to the parole authority?
No, sir.
Do you understand that on each of these drug charges in both cases, they may result in a driver's license suspension of between 6 months and 5 years?
Yes, sir.
Do you understand that with the failure to comply in 860, there is a mandatory driver's license suspension of at least 3 years up to your lifetime?
Yes, sir.
You understand that your felony convictions will prevent you from owning or possessing a firearm?
Yes, sir.
Do you understand that if a prison term is imposed in this case, you might have to serve a period of post-release control as part of your sentence for up to 2 years under the parole authority?
Yes, sir.
If you are placed on post-release control and violate any conditions, the parole authority can send you back to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, sir.
If that violation of post-release control is a new felony, you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes, sir.
If that were to occur, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, sir.
Do you understand if a prison term is imposed, you are eligible for judicial release?
Yes, sir.
You could be placed on community control for up to 5 years on each of these cases, but if you violate, I could send you to prison for a total of 66 months. Do you understand that?
Yes, sir.
Has anybody promised you I would be lenient on you just because you're pleading guilty today?
No, sir.
Has anybody promised you what I will sentence you to in this case?
No, sir.
You understand I do not have to follow the sentencing recommendation of either the prosecutor or your lawyer.
Yes, sir.
Have you had enough time to talk to Mr. D before pleading guilty today?
I have.
Has he discussed everything about your case and answered all of your questions?
Yes, he has.
Are you satisfied with the advice he has given you?
I am.
Have you been threatened or coerced in any way to plead guilty today?
No, sir.
Are you freely, knowingly, and voluntarily entering your guilty plea?
I am.
Do you have any questions?
No, sir.
All right, Ms. Gold, if 860 went to trial, what would the evidence show?
Thank you, Your Honor. The facts would show that on June 1st, 2026, officers in Willowick, Lake County, Ohio, attempted to initiate a traffic stop on a vehicle the defendant was driving. They gave a visible and/or audio signal to bring the defendant's motor vehicle to the stop. The defendant was in a motor vehicle as defined in Revised Code Section 4501.01, and after receiving such a signal, the defendant failed to bring his vehicle to a stop. When he was eventually stopped, his car was searched and officers located suspected controlled substances, which were taken to the Lake County Crime Lab and tested positive for less than bulk amount of methamphetamine, a Schedule II controlled substance, and a fentanyl-related compound, a Schedule II controlled substance.
Mr. Deeb, anything to add to those facts?
No, Your Honor.
All right, Mr. Murphy, did you hear what Ms. Gold said the facts would show if this case went to trial?
Yes, I did.
Are those facts true?
They are.
What is your plea to count 1, failure to comply with the order or signal of a police officer, a felony 4?
Guilty.
What is your plea to count 2, aggravated possession of drugs, a felony 5?
Guilty.
What is your plea to count 3, possession of a fentanyl-related compound, a felony 5?
Guilty.
What is your plea to the forfeiture specifications in counts 2 and 3?
Guilty.
Ms. Gold, if 882 went to trial, what would the evidence show?
Thank you, Your Honor. The facts would show that on May 10th, 2026, officers in Painesville, Lake County, Ohio, had reason to approach the defendant and his vehicle, which was stopped at a gas station. This stop resulted in a search of the defendant's car where officers located suspected controlled substances that were taken to the Lake County Crime Lab and tested positive for less than bulk amount of methamphetamine, a Schedule II controlled substance, and a fentanyl-related compound, a Schedule II controlled substance.
Mr. Deeb, anything to add to those facts?
No, Your Honor.
Mr. Murphy, did you hear what Ms. Gold said? Those facts would show if the case went to trial.
Yes.
Are those facts true?
Yes.
What is your plea to count 1, aggravated possession of drugs, a felony 5?
Guilty.
What is your plea to count 2, possession of a fentanyl-related compound, a felony 5?
Guilty.
And what is your plea to the forfeiture specification voluntary waiver? He understands the nature of the charges, the consequences of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, voluntary. I will accept the defendant's plea of guilty in both cases. On 860, find them guilty of count 1, aggravated possession of drugs, count 2, possession of fentanyl-related compound and the specifications. 882, guilty of count 1, failure to comply, count 2, aggravated possession of drugs, a felony 5, count 3, possession of a fentanyl-related compound, felony 5, and the specifications. I'll refer these for a pre-sentence report. Sentencing will be September 30, 11 o'clock. 860, the bond remains revoked. 882, the bond is revoked. Anything further?
Your Honor, I was going to request a drug and alcohol. We're going to be requesting treatment, which is unusual for Mr. Murphy.
When was the last time he was sentenced?
Approximately 1 year ago, maybe 14 months ago. I don't have the specific date.
No, it's longer than
And when was he? When did he get?
It was longer than that. I'm sorry, Your Honor.
When did he get out of prison?
January of 25.
All right, drug and alcohol evaluation also.
Yeah. That's what I was thinking, Your Honor.
Anything further, Ms. Gold?
No, Your Honor, thank you.
It sounds,
Steve?
it sounds right. Yeah, nothing further, Your Honor.
All right, we're adjourned.
Okay, I'm going to